question for Mr. Verghese and Mr. Mohan, given that both of you mentioned this issue of rat hole coal mining, and there is a problem in terms of environment and subsidence of the soil, ground, etc. But what would be the kind of balance that Mr. Verghese talked about in this regard? About because I would have thought that one of the reasons why rat hole mining is so prevalent is probably because the land is common, and those who are doing it are able to get around either by subverting the traditional authorities or by bypassing the modern state authorities. And since it's common, there's probably a rent seeking involved by some agency at some level to allow it to happen. So what would be how would you manage this kind of incidents if particularly that that you don't have modern mining facilities there, the ownership is undefined, and the locals want to exploit the resources to the extent they can, and consequently everybody else pays the price for the way it is done. So how the balance would be achieved?
Can I just add on before you answer? The Parliamentary Committee report on mining shows that we have only around 14,000 legal mines, and we have more than 84,000 illegal mines in the country. So the rat hole mining is part of those. Yeah.
So, the land owning problem is the same, I think, in the case of Garo Hills and in the Khasi and Giant Hills. Because basically, traditionally the land is being owned by the community. But as time goes and, people realize that the benefit that they can reap from, owning the land, then they decided to apply for, in Giant Hills and Khasi Hills, they call them land holding certificates. Maybe in Garo Hills they call them pata, but in Giant Hills and Khasi Hills they call them landholding certificates. So once people acquire the land in on their respective name, in the separate landholding system, then it belongs to them. That is the case in Giant Hills. All the in the mines are owned by private individuals, and so that is why it's very difficult to control and manage mining. And moreover, the government is not in favor of using the the national mining laws or the national because on the pretext that it's the land belongs to the local people, and they are protected by the sixth schedule. So that is the crux of the matter. And in my opinion, the solution to this is for the government to put a step forward and control and manage mining in the state. And I was part of the committee that come up with the drafting, the mines and mineral policy of the government of Meghalaya, and we were hoping that this policy will be some kind of a regulation to some kind of where none has exists. There's no mining regulation as such. But then the government till now, it's not willing to implement that. So I don't know the way forward.
I have a slightly different point of view, and I have long argued that without doing any injury to the concept of a tribal collective holding, one needs to deal with the problem because A, it is very unhealthy, it is extremely dangerous to life and limb because of spontaneous combustion. It is extremely wasteful of the coal because you only extract about a third of the coal that is there, and you make such a mess of the place that further mining is very complicated. And fourth, no controls, because the end product of this is massive illegal smuggling of coal to Meghalaya, about 1,500 crores of rupees, which has resulted in the growth of a huge mafia. And these have got protective cover with guns and arms, so the whole thing is an absolute mess. So I think the answer there, and which I have long advocated, is that the negotiations should take place to say that these areas within the collective jurisdiction of whatever clan it may be, first, they should be surveyed by some state body like the Northeast Coalfields Limited, which is a public enterprise, headquartered in Margarita or somewhere there in Upper Assam. And then a proper scientific mining plan be prepared so that it can be then managed by the local people as a cooperative with the technical assistance and support, including marketing, of a body like the Northeastern Coalfields or Coal India or whatever, or a totally new body that might be set up. This would be in the interest of the people, because while there may be small gains to individuals, there are huge social losses. Not merely in terms of the coal that is lost, but in terms of the injury to life and limb, the total environmental devastation. For miles on end, the whole countryside is black. The trees are black with coal dust. So this is a sort of tremendous hazard. So one can't sweep it under the carpet by saying that it cannot be touched. This is where I say that we've got to safeguard the future, and we've got so lost in nostalgia that we are tripping over ourselves and shooting ourselves in the foot. And this is something that I think would be entirely practical, would fit into the tribal ethos of collective ownership or cooperative ownership, and then transform this from a negative to a positive sum game.
Thank you so much to all the panelists for very illuminating presentations. I have a lot of questions, some of which relate to issues of property and land ownership, and others that relate to representation, as well as how do we understand tribal rights. So one of the starting things, and I think this is relevant to all the panels as well, and it goes back to the point about whether the autonomous district councils are representative, because my understanding of the way the 6th schedule was created and the way these bodies are appointed, they're not truly representative of individual representation as we understand it in the rest of the country. So in that sense, when we talk about tribal rights, we're essentially talking about some kind of group rights, but the way they've sort of manifested themselves, whether it is the control of the Nokma, not really being the custodian, but acting sometimes as the owner of the property, and really not representing the rights of the family or the group that he's the leader of. So I mean, really, this question of individual rights versus group rights and how that forms, how that comes through in representation on autonomous district councils, and whether those bodies are truly representative of the rights of the people. So that's the first question. The second question I have is, it seems like this whole property ownership structure is extremely complicated. And there's no real clarity as to, there are several different things here. One is about regulation of property arrangements, which is the function of the state. And within that, there seems to be this conflicting jurisdiction between the district councils, between the Nokmas and the traditional heads. So that's one layer of the issue. But then there's also how does the communal ownership manifest itself? Because the way lawyers understand property as a bundle of rights, so you have the right to use property, the right to sell property, the right to and then even within property over land, there is a right to use the resource, the land, and then there is a right to use the resources under the land. And the way that property was understood in British India, which sort of continued into the post-colonial period, was that the state owned all the resources under the soil. So the idea was, there were different land tenure systems in all of the country. There was zamindari in some parts, rayatwari in others, the jhum cultivation in the northeast. But that mineral resources under the soil belong to the state. Now, there's been a recent Supreme Court judgment that has disagreed with that. But for the most part, that's why the state has the power to give mining leases even in areas under these schedules. So Could you clarify how the situation plays out within the areas in the Khasi, Garo, and Jaintia hills, on both property ownership as well as of the land and then under the soil?
Let me first try to describe the structure of traditional system in the Khasi and Giant Hills. We have heard about the structure in the Garo Hills, but in Giant Hills, and in the same, it's the same thing in the Khasi Hills. In Giant Hills, we have in the village level, we have the Dorbar Shnong, or the Dorbar Shnong in Giant Hills, and then in the upper level, then we have in the Giant Hills, we have the Dolois. The Dolois is a traditional head, and it's being elected by the people. But that's in Giant Hills. But again, your question about the representative, whether this institution is representing people. In the case of the Dolois, only male can vote for the Dolois. The Dolois office is for a life. And in case a Dolois died, only a person belong to a certain clan can become a Dolois. Okay? So, and again, to elect a Dolois, only male member of the community can take part in the election. And in the case of the Khasi Hills, we have this aims. This aims, we have many aims. We used to say 30 Kilaipus aim, re of the 30 kings or royalty. And they are, this is, it's like any other royalty. It's just goes through the lineage of the royal family. Okay, but in the case of that king also, it's wrong to say that's the lineage. But then there is the Dorbar also, Dorbar's aim, and there is even in the Doloiship also there is a Dorbar Eleka. But in both the cases, it's almost all male members who are member of this community. Even in the case of the grassroots level in the Dorbar Shnong, only very recently the women were allowed to participate in the Dorbar Shnong. But then till now we have not had a case where a woman can become a Rangba Shnong, because the term itself does not qualify woman. It means Rangba Shnong. Rangba means a man. It's like village chief. It should always be a man. So, that is with regard to the question of representation. I used to question this in my write-up that when the traditional institute does not really represent the community as such. But in case of the district council, they are elected, through through the franchise, as any other, as the member of parliament or the member of assembly. And in the case, in all the 3 district councils, we have 29 members, and 1 is nominated by the state government. But with regard to the relationship between the state and the district council, unlike the other district council in Assam and maybe somewhere else, the district council in Meghalaya are in a because there is what we call the 12th schedule of the constitution, which allows the state government to overrule any rule which they have, of the same interest between the state and the district council. Then this is called the 12th, para 12. Sorry, it's a para 12A. It's a para 12A. Then the government can overrule the rule, any rule made by the district council. So that is basically about the relationship. Do you have another one question?
It was about property rights.
Yeah. Okay. With regard to property right, again, even in Giant Hills, it's different in different areas. Like in the Warjantia areas, this is the area which is in the border with Bangladesh. It's similar to what you call the landlord system, or what you call the zamindari system. The zamindari system. Only in the case of In the case of the Varjanti area or the Amlaram, that area falls in the Amlaram subdivision. The land is owned by the community. Land is owned by the community. But what happened with this community-owned land is that ultimately only the family, of the youngest member of the family own the land, or she's in control of the land. She's in control of the land. And suppose if they, like what happened now in Nongtalang, suppose there's a land that belongs to the clan, mostly the clan, and they have 5 sisters. The lion's share will go to the younger sister. And, and it depends on the Kni, which is the maternal head in the family, the maternal uncle, I mean to say, the maternal uncle, she will have the right to decide to whom, but the tradition is that the lion's share should go to the youngest daughter or sister. And with regard to the owning of land, I was...
unique. I've never heard of the youngest ever.
It's youngest.
In any system.
It's in all the 3.
It's all, it's the youngest. They believe that the wisdom is that because the youngest sister is supposed to live longer with the parents. Yeah, but with regard to the community-owned land, till very recently, when we protested against the Lafarge plan to mine in Nongkli area, where we have a huge concentration of caves, exotic caves in that area. So we decided that we need to protect this area. So we protest. And when I went to that area, I met some people, an elderly of the village, who said that they never registered their land. The community had decided till that point of time that they will not register their land. And they still maintain that tradition that the land belongs to the community. As long as I farm this land, it belongs to me. But the moment I stop farming the land, after 3 years, there's this stipulated time that after 3 years, if I continuously leave the land without touching it, it goes back to the community. That was practiced till recently. But then after the Lafarge came and people realized that there's something underneath the ground, so that has changed. People have started register their land in that area now. It reached to a point where in the Giant Hills Autonomous District Council, they have a separate department for revenue. But with regard to the land in Nongkli area, which has a huge concentration of limestone, the subject is now being controlled by the chief executive member, while the rest of the district is being controlled by another executive member. So,
In terms of the legal arrangement, is there clarity about the fact that the resources under the land also belong to the people who have ownership, communal or otherwise, over the land?
right now, what happened is that whoever owns the land, who has the land holdings of that particular plot of land, and everything belongs to him. That's the understanding.
I think we don't really have more time to go on, but I'm going to be a little bit greedy here because I'm chairing. I have just one last question for you, Melville. This data which you showed us with 82% and 16 and 2%, that has actually come as a little surprise for me because I've not read too much about it, but it seems that most of the studies which have been done, they kind of do not like the idea that the land should be privatized, or if you put the patta, then you are individualizing the land, if one may say, if not privatizing. And in that, what comes to fore is not just who owns the land, but a varied host of issues such as which B.G. Varghese had pointed out, that Jumia is not environmentally sustainable. But at the same time, one of the effects, if we offer them plantation crops, that kind of individualizes the land again, because zooming is what you do communally, right? And you do it this year, and the 4th or the 5th year someone else could be given that land by the community. But when you put cash crops or plantations, then you are kind of pushing it towards the individualization. You're pushing the people that they own the land. Yeah, but at the same time, it's also a question of bioconservation. I mean, what are the cash crops we are looking at? Like there's been in Khasi Hills, probably, please correct me if I'm wrong, that they went ahead with this broomstick cultivation, and in hordes, in large numbers, and broomstick does not allow any other crop after it has been grown. So it's something very close to indigo farming almost, and then what after the broomstick period has gone down, and now the plastic brooms have come up, what do people do about that? So here I think I just want, before we close for tea, I just want to put this in a perspective for the project itself, because we are not just dealing with the land rights and who owns and who makes money, but also what happens to the ones who have been marginalized. So it's a lot about accountability, as Professor Mazumdar was saying. And what is happening in Meghalaya, or under 6 kilo, or at least in Meghalaya, is that a host of overlapping jurisdictions and a hazy accountability. And once we are not able to trace who is owning the land, we are not able to trace the accountability. And there comes all the other problems with the legal, the social, the economic, the political. So I think that we have to bear in mind, and that kind of probably, to my mind, is a good point to end this panel here. And we really look forward to the other 2 panels. Thank you very much. And there is tea for everybody now. Thank you.
Thank you. Thank you, Kavita. And so we'll now break for tea. Tea is outside on the terrace. I think we should be back in about 10 minutes.
No. It's not working. 20 minutes. No, it's not working.
Okay. Good afternoon, everyone, and welcome back. We're now going to start the panel on Gujarat, rights of tribals and other traditional communities. But before I start, there's an attendance sheet that is circulating around. So please do fill in your details and give them to Pallav at the end. So we'll just start with the panel. Now, Gujarat has a statistically quite significant tribal population. We were just discussing in the morning, where the numbers vary in different reports, but it is about 14 to 15% of the population is tribal. But at the same time, there are very few listed scheduled areas under the 5th schedule. But Gujarat also, as does the rest of the country, have many traditional communities, including the traditional fisher folk community, which is mostly in the Kutch area of Gujarat. So in this panel, we have a very interesting mix of presentations. The first 2 presentations will be by Mr. Amrish Mehta and Mr. Varun Mitra, both of which will focus on the land and forest rights of tribal populations. The third presentation will be made jointly by Kanchi Koliye and Bharat Patel, and that will focus on the rights of the traditional fisher folk community. So to introduce the panelists, Mr. Amrish Mehta, on my left, is a trustee and full-time activist at the Action Research in Community Health and Development in Gujarat, the ARCH, or also known as ARCH or Arch Wahini. Mr. Mehta has worked extensively on the implementation of the Forest Rights Act in the tribal districts of Gujarat, and he will be speaking on the status of land rights of tribals in Gujarat, a case for the implementation of the Forest Rights Act. Then we'll have Dr. Varun Mitra, who is the founder and director of the Liberty Institute, a non-profit independent public research and advocacy organization based in Delhi. Mr. Mitra is a commentator on current affairs on a range of issues, from economic development to conservation of wildlife, and from property rights of the poor and marginalized sections to intellectual property and access to healthcare, etc. He has written extensively in national and international newspapers and has been awarded for his contribution to international environmental policy debate. He will be speaking also on the Forest Rights Act and its impact on law, politics, and economics. Then we'll have the third presentation by Kanchi Kohli and Bharat Patel. Kanchi Kohli is an independent researcher, writer, and campaigner working on environment, forest, and biodiversity governance in India and their interface with trade and industrialization. She has individually and in teams with various organizations like Kalpavriksh and also Namati worked on these issues both at the grassroots level as well as been a part of national and international advocacy and research campaigns. Bharat Patel is a full-time activist and is the executive director of the Machhimar Adhikar Sangharsh Samiti. He's also an executive committee member of the District Coastal Management Committee and the National Fish Workers Forum. I've been fortunate to have a long association with both Kanchi and Bharat on some of the cases involving displacement and deprivation of the rights of the traditional fisherfolk community in Gujarat. And they will be jointly presenting on land use, land grab, and environmental regulation in Mundra. So without further ado, I will hand over the floor to Mr. Mehta.
Thanks, Namita. And as he said, I have been working mainly in the tribal areas of Gujarat for past 30 years. Initially for the rehabilitation of the families, tribal families affected by the Sada Sarovar project, Narmada project. So on that issue, I worked for about 15 years, and then other forest rights related issues. And for past 5 years, mainly concentrating on Forest Rights Act. So since now we have to talk from Meghalaya to Gujarat, I think before I start talking about Forest Rights Act, it would be a good thing to give you an idea of what the tribal areas of Gujarat are and what is their brief history of land ownership and forest ownership and other things. So coming to that, I don't have much of a study academic background. Whatever I would be saying would be largely based on the discussions I had with the tribal elders and also following some of the government reports and examining some of them. So that is largely the source of the things which I will be telling. Because working with these on these issues, working with these tribals on these issues gave us a lot of opportunities of discussing what happened in the past, what was the situation in the past. And that has also given us a key insights into what has been happening in this area. Coming to the tribal areas of Gujarat, we have many tribes from Bhils and Bilalas, Basawas, Rathwas and others. But mainly the all tribal belt of Gujarat is located in the eastern part of the state. It is a narrow belt. It is surrounded by Rajasthan, Madhya Pradesh, Maharashtra. These are the three states which are surrounding this tribal belt. And none of them were directly under British rule. Historically, these areas were largely ruled by local kings or local kingdoms, largely Rajput kings. Mainly in one of Langs, for instance, it had a Bhil or Vasawa. They are local tribal kings, but otherwise largely ruled by Rajput kings. In all these areas, there were Jagirdars because for collection of land revenue, but most of these kingdoms have very close relations with British. Most of them had British residents stayed with them. And so land settlement process here was quite advanced. In all these areas, all the lands have been surveyed. All these surveys were carried out in 1920. They were supposed to be redone after 50 years. That has not happened. But in early 90s, these surveys were done. And land collection of land revenue was through each king had these many villages for this Jagirdar, and they were collecting tax revenues from this tribal. So tribals were technically legally tenants of that owner or Jagirdar or Dumaldar, and many other systems were there. They were independent cultivators. Their land had been surveyed and they were given settlement title ownership also. Whatever land they were privately cultivating, not others. So individual land ownership and individual agriculture is being practiced throughout from the beginning. There was no communal agriculture. no communal agriculture in tribal areas of Gujarat, and if I am not mistaken, also not in Madhya Pradesh, Maharashtra, and other states. So that was there. What was the system which was there under these Jagirdars was that although people would cultivate their own lands, they also were forced to supply labor to the Jagirdar on his own land, which was quite of a serfdom type of a system. So when this was abolished after independence, the first thing that happened after independence in this area was that these Jagirdars, these systems and Dumaldari systems, they were abolished, and all the families become title holders of the lands which they were cultivating. And many tribal elders say that this was the first air of freedom that they breathed. This was something because going to the Jagirdar's land and work without any payment for continuously every year, year after year, was something that they considered it as serfdom, and they regretted it a lot. And that is why they were very happy that this system was abolished post-independence. Not only this has also some bearing on the land holding patterns. Because you were supposed to go to provide free labor, they never subdivided, and this labor has had to be based on the holdings. So they never subdivided their holdings. Although there are 5, 7, 8 families dependent on a holding, the holdings would be named or owned by only one person. The rest of the families would not, because so that it would reduce the amount of forced labor which they would have to give. So that was first thing that happened during that time. Under the princely states, forests were owned by the kings. And these are, I'm talking about largely about the forest areas. Forests were owned by the kings, but local communities had a lot of say and a lot of control on using of the forest resources, even selling timber, wood, and other things. Not great many restrictions were there. Britishers came out with this idea of nationalizing the forests. They never had this direct rule on the parts of Gujarat forests, but most of them had this, as I said, they had influences with the local kingdoms. So some sort of a forest management, forest working plan systems were put in place even before the independence in those areas. That had also come into being. What happened thereafter and during this period was that that after independence, they formally became reserve forests, and large chunks of lands were declared forest areas. What happened in between with Dang exception? One exception was Dang. Dang, Britishers were very much interested in Dang forest. It was near the Bombay, and they needed Dang teak very much. So although there was a tribal chief there, they had a special arrangement, and they never ruled. So, but they had an understanding with the tribal chief that it would declare 50% of the land as reserve forest, and the Britishers would be free to take away all the timber from this area, and pay some annual revenue to the tribal king.